Be ready? Start. The courts have observed that when the law making power of a state is restricted by a written fundamental law, then any law enacted which is opposed to such fundamental law, being in excess of fundamental authority, is a nullity. Stop. Inequality is one such example. Stop. Still, reasonable classification is permissible under the Indian Constitution. Stop. Surrounding circumstances can be taken into consideration in support of the constitutionality of the law, which is otherwise hostile or discriminatory in nature, but the circumstances must be such as to justify the discriminatory treatment or the classification subserving the object sought to be achieved. Stop. Mere apprehension of the order being used against some persons is no ground to hold it illegal or unconstitutional, particularly when its legality or constitutionality has not been challenged. K. So and so versus State of Kerala and another within bracket 2003 SCC 761. Stop. To raise the plea of Article 14 of the Constitution, the element of discrimination and arbitrariness has to be brought out in clear terms. Stop. The courts have to keep in mind that by the process of classification, the state has the power of determining who should be regarded as a class for the purposes of legislation and in relation to law enacted on a particular stage. Stop. The power, no doubt to some degree, is likely to produce some inequality, but if a law deals with liberties of a number of individuals or well defined classes, it is not open of the charge of denial of equal protection on the ground that has no application to other persons. Stop. Classification thus means segregation in classes which have a systematic relation usually found in common properties and characteristics. Stop. It postulates a rational basis and does not mean herding together of certain persons and classes arbitrarily as already noticed. Stop. The differentia, which is the basis of the classification, and the object of the act are distinct things, and what is necessary is that there must be a nexus between them. Stop. The basis of testing constitutionality, particularly on the ground of discrimination, should not be made by raising a presumption that the authorities are acting in an arbitrary manner. Stop. No classification can be arbitrary. Stop. One of the non-concepts of constitutional interpretation is that the legislature cannot be expected to carve out classification which may be scientifically perfect or logically complete or which may satisfy the expectations of all concerned. Stop. The courts would respect the classification dictated by the wisdom of the legislature and shall interfere only on being convinced that the classification would result in pronounced inequality or palpable arbitrariness tested on the touchstone of Article 14 of the Constitution. Stop. Welfare Association of Allottees of Residential Premises, Maharashtra versus Ranjit P. Gohil within bracket 2003 9 SCC 358. Stop. Over.